Good morning or good afternoon to you all. First, some housekeeping. There's Arabic interpretation for the event today. Please choose the language you want to listen in the interpretation channel below, and then you can listen to either Arabic or English. We'll record the event, but your own video or the chat won't be visible in the recording. Okay, let's get started. My name is Jessica Hagen-Zanker, and I'm a senior research fellow on migration at ODI. We are a global independent think tank that harnesses the power of research, evidence, and ideas to confront challenges, develop solutions, and create change. I would like to welcome you all to today's webinar, where we'll be discussing extending social protection for migrant workers in the GCC, the state of play, and next step for reforms. I've worked on both migration and social protection for a long time, and the need for social protection coverage for migrant workers and their families has long been clear. While social protection coverage globally has grown rapidly over the past decades, some groups are left behind, including migrant workers. At the same time, we don't always have good data on the extent to which migrant workers are covered on paper and in practice. And that's exactly the starting point for today's conversation. The discussion today builds on new insights emerging from an ILO-ODI collaboration on extending social protection to migrant workers, which is building both research and policy dialogue in the Gulf cooperation countries. We invite you to take a look at the reports we've published today, which have inspired today's discussions. So today's discussion will focus on 4 key areas: social protection in the MENA region as a whole, including current practices and why reform is needed, an overview of migrant workers' legal social protection coverage in the GCC, a conversation on the challenges with regards to end of service indemnity and potential reforms, and also finally some insights into migrants' experiences of actually accessing social protection in the GCC. I'm excited to say that we have a fantastic panel with us today. Bringing together different perspectives into this conversation is vital. And our speakers are involved in ongoing efforts to extend social protection to migrant workers in the GCC from across the policy, research, and civil society spaces within this GCC region and beyond. Here with us today, we have Khalil Buhazaa, Labour Affairs Director at the Council of Ministers of Labour in GCC states, who will share perspectives from the GCC region. Welcome. From the ILO Regional Office for the Arab States, we're joined by Luca Pellerano, Senior Social Protection Specialist, and Leah Buhazaa, Social Protection Technical Officer, who are leading on ILO's work with government, employers, and workers to extend social protection in the GCC. We're also joined by William Goyce, who is Regional Coordinator of the Migrant Forum in Asia. You might know them as MFA, which is a regional network of grassroots organizations, trade unions, faith-based groups, and migrants workers, and they're working for social justice for migrant workers and members of their family across Asia and the Middle East. And we have Patricia Barandun, Head of Section, so Migration and Forced Displacement at the Swiss Agency for Development and Cooperation. And she's going to offer reflections on the implications for the international community. And finally, Christy Lowe is with us. Christy is a Senior Research Officer at ODI, who will bring valuable perspectives from the research community. Christy, along with myself, Leah, and Luca, and other colleagues, has supported the evidence base that will be vital to drive the change we're working towards. Thank you all for being here today. I'm also very happy to say that we're expecting over 100 people to join us today from a variety of different sectors and regions. We're thrilled to have you here. We will have 2 Q&A sessions. Please use the chat box to raise questions for our panel throughout the session, and we'll discuss them during the Q&A sections. Without further ado, Luca is now going to set the scene, and we'll then move into the main event. Welcome, Luca.
Thank you very much, Jessica, and a warm welcome to all participants also from the ILO. Social security is a basic human right for all, and during the course of the last century, social protection systems have seen impressive growth. However, just over half of the global population, more than 4 billion people, still lack access to any social protection benefits. Amongst these, migrant workers continue to receive lower levels of protection. Lack of adequate and comprehensive social protection has profound impact on the lives of migrant workers and their families. It means migrant workers have no option but to continue working when sick or pregnant. It means they avoid health care when it is too expensive. It means they face individually the long-term economic consequences of injuries on the workplace. It means they live in the uncertainty of their financial security in old age. In the absence of strong social protection mechanisms in the country that benefit from migrant labor, workers are too often left to manage risks on their own. In practice, it is either migrant workers' own families and community networks or social protection systems in sending countries that bear the burden of the needed protection. The challenges of extending social protection to migrant workers are particularly evident in the GCC, where migrants comprise between 76 and 95% of the workforce, as you can see on the slide. The kafala system has reinforced the notion of social protection as an employer-provided responsibility as opposed to a worker's right. It is also the basis of a segmented labor market and of a dual social protection system, with large inequities in benefits between national and non-national workers. Social protection arrangements are conceived for short-term migration horizon and therefore focus on immediate work-related risks, offering very limited protection as workers move on. But why has it been difficult for migrant workers to participate and benefit in social protection schemes? In one of the papers that we're launching today, we discuss 3 types of barriers that migrant workers face in accessing social protection in the Arab region. First, legal barriers prevent coverage either on the basis of nationality, employment status, or the sector in which migrant workers are employed. Workers in more vulnerable sectors, such as the domestic sector, agriculture and fishing, or construction, or in new emerging forms of employment, such as those on flexible visas, in the platform economy, or in irregular status, are at much higher risk of falling through the cracks. Second, practical barriers hinder access even when basic legal rights are provided. These have to do with low compliance with the law, lack of information regarding rights, and complex procedures for registration. Finally, not all migrant workers that participate in social protection adequately benefit because of restrictive eligibility conditions, lack of effective mechanisms to claim benefits upon return or by the families in the unfortunate event of death, and also because of the absence of social security coordination between countries of origin and countries of destination. So where to go from here? As early as the founding of the International Labour Organization in 1919, the preamble to the ILO Constitution recognized the importance, and I quote, of protection of the interests of workers when employed in countries other than their own. You can find details of relevant conventions and instruments in the papers and on the project page. But for now, I think it's important to just stress few principles so that you can keep this in mind on the course of today's webinar. Migrant workers, like all workers, are entitled to comprehensive and adequate benefits. Benefits that must be periodical and predictable, including regular payments in the form of pensions for long-term risks. Social protection systems should be built on the basis of collective financing and broad risk pooling, with sufficient participation in financing from the employers, and solidarity, as solidarity is what differentiates social insurance from private insurance. Governments must ensure that the rights are enforceable and accessible. There are also principles that apply to migrant workers in particular. The cornerstone is equality of treatment and non-discrimination between national and non-national workers. ILO standards also require that benefits should be portable and exportable, so to prevent migrant workers from losing access to rights and benefits they have acquired as they move. As we will see during the course of the discussion, for historical, political, economic reasons, GCC countries are far from the full realization of such standards. However, there is reason to believe that progressive change is now possible. The COVID pandemic has revealed the insufficiency of employers' finance mechanisms, leaving many workers unprotected, businesses' finances strained, and an unsustainable burden on overstretched labor dispute mechanisms and labor courts. There are also positive examples from the Arab region that can serve as inspiration. As one of the papers that we launched today describes, many countries in North Africa and the Middle East have extended access to short as well as long-term social insurance benefits to migrant workers on terms of equality of treatment. And most importantly, there is now a new momentum for social security reforms in the GCC, including in the context of the ongoing attempts at reforming kafala. Several countries are taking legal steps to extend employment injury and unemployment insurance, broaden coverage of health insurance, and rethink end-of-service entitlements, which is the topic of the third paper we launched today. A subject that was impossible to table just a few years ago is now openly debated, with the GCC Bureau and national level taking concrete steps of reform. The new signs of change and reform momentum present an important shift in the landscape and can bring benefits not only in securing the rights and well-being of migrant workers themselves, but also for wider stakeholders, including employers, governments of sending and receiving countries, and their economies and societies as a whole. Extending social protection is essential to steer away from an economic model based on low wages and low productivity, including by attracting and retaining high-skilled workers. But also improving social protection rights is key to reducing unfair competition in the labor market and promote internal labor mobility that can attract both national and foreign workers to the private sector on a more leveled playing field. Strengthening collective social protection can contribute to the regional agenda of economic modernization and structural diversification, as employers can be shielded from liquidity constraints during economic shocks and downturns, and governments can align contributions and savings with national investment priorities. Progressive movement towards equality of treatment can also solidify social cohesion and improve the reputation of GCC countries and businesses, improve the sustainability of social security systems, and finally contribute to the migrants' safe and regular international mobility, including eventually their return to countries of origin. In closing, international social security standards can and should provide a compass to chart the way ahead. And indeed, the extension of social protection to migrant workers can only be considered within the broader labor rights agenda. Efforts to advance social protection need to go hand in hand with ensuring that wages are paid, working conditions are adequate, fundamental principles and rights at work as respected, and occupational safety, health and safety standards are observed. I would like to thank ODI for organizing this event and acknowledge the support from and the partnership with the Swiss Development Cooperation on this agenda. Governments, workers and employers organizations in both sending and receiving countries face now, today, an opportunity to seize this new momentum and make social protection a reality for all workers in the GCC. Broad partnership and social dialogue will continue to be the only way to achieve sustainable change.
Thank you, Luca. We'll now turn to Christy, who will share the latest analysis on coverage of migrant workers on the legal side. And in 20 minutes, we'll move into our first audience Q&A. So please do submit your question throughout. And I wanted to clarify, please submit them into the Q&A and not the chat. Thank you. Over to you, Christy.
Great, thank you. Can you see my screen okay?
Yes.
Perfect. Okay, well, welcome everyone. Thanks so much for joining. This presentation focuses on some key findings related to our analysis of migrant workers' rights to social protection in the GCC. And this presentation relates to one of the outputs that was just launched on our project page, which is the review of national legislation on social protection and migrant workers in the GCC. The legal review was conducted by law firm Clyde & Co, and the analysis and write-up by ODI in partnership with the ILO. We won't have too much time to go into the detail today, but please do check out the full report on the project page. We'll be sure to share a link in the chat. So for this legal review, for each of the 9 social security contingencies, we mapped the provisions available for both national and migrant workers employed in the formal private sector. And we focused on the private sector because, as Luca mentioned, it's overwhelmingly dominated by migrant workers in this region. So it's really important to understand the entitlements for that sector, and also to understand the extent to which those entitlements are actually open to workers from outside of the GCC. We do also look at the provisions available for those outside of the private sector, like, for example, domestic workers who aren't covered by private sector legislation, but I will come to that in a minute. So you can see the full mapping here, but in terms of the broad findings, which is what we'll be covering today, we see that, first of all, private sector provisions are still relatively weak in general in the GCC, even for the few citizens who work in the private sector. So, for example, for GCC nationals, there's currently no social insurance in place for sickness, maternity, and in many cases, employment injury too. And that means that there's a heavy reliance on what we call employer liability, meaning the employer is directly responsible for covering the benefit in the event that a risk occurs. However, there are some encouraging reforms underway in Oman to develop a social insurance scheme that covers these 3 contingencies. And then beyond the general provisions in place, we're of course specifically interested in whether those provisions are open to non-GCC citizens. So here we find that the legislation does cover migrant workers, but only for certain risks. So specifically, migrant workers do have the same rights as citizens employed in the private sector for sickness, maternity, and employment injury on the whole. In relation to medical care, migrants historically tended to access public health systems in the GCC, but in recent years, there has been a shift to covering them instead through mandatory private insurance for non-emergency care. And those are the red blocks that you can see there on the diagram. On top of that, we see that migrants typically have no right to provisions that are independent of the employment relationship. So, for example, for unemployment insurance in all cases except Bahrain and a private UAE scheme that was recently introduced. Also no entitlement to family and child benefits, and also old age, disability and survivors pensions. Instead, the only entitlement that migrants typically have after leaving a job has been the end of service indemnity, which is a lump sum payment given at the end of the contract. But this is not in line with minimum standards of protection for old age, disability and survivors, so it shouldn't be viewed as an adequate substitute for a pension. In addition, there are some groups of migrant workers that are not covered by private sector legislation, in particular those whose residence is or has become irregular, or those who have entered into informal employment. And also domestic workers are generally not covered by the social protection provisions in labour laws, except the provisions relating to end of service benefits in the case of Bahrain's labour code. However, there are a few social protection provisions in new domestic worker laws that have been passed in Kuwait, Qatar, Saudi Arabia, and the UAE over the last decade. But it's worth noting that these benefits are typically below the levels that we see in private sector legislation. So what does this mean in terms of broad trends? Well, it is encouraging to see that we've seen some expansion in coverage. and also that there's been a definite move away from problematic employer liability arrangements, or the start of a shift anyway. But the direction of travel has really been quite split between two different directions. So one is the adoption of policies requiring mandatory private insurance that is often publicly regulated, but a private-based solution nonetheless. So for example, we've seen this trend towards private health insurance for migrant workers across the GCC, which does need to be carefully considered because it has the potential to reduce elements of solidarity in financing and risk sharing, to widen access gaps, and also to increase cost and fragmentation. In the UAE, we've also seen the introduction of a policy requiring workers to pay for their own private unemployment insurance. And in Dubai, there's been some shift to replace the end of service indemnity with a mandatory private pension for certain workers. Then on the other hand, we've also seen a positive reform trend that's very much in line with international social security principles of universality and solidarity in financing and risk pooling. And that's the inclusion of migrants in national social insurance systems. So for example, in Bahrain and Saudi Arabia, as we saw, migrants have been included in social insurance for employment injury and also unemployment in the case of Bahrain. In Oman, the new social insurance scheme that I mentioned that's going to cover sickness, maternity and employment injury is expected to cover both citizens and migrant workers together. And then various GCC governments are looking at how they can strengthen the provision of end of service indemnity, strengthen the state's role in that, for example, through a state managed fund to administer those benefits. Which takes us on to the final slide of forward-looking areas then. And here there are a few key policy actions that we highlighted in the report. The first is the need to ratify and implement key international conventions and align with principles enshrined in international and regional declarations relating to social protection. The second is to keep up the momentum on some of the positive reform trends, including strengthening social insurance provisions in general and for migrant workers, inclusion in social insurance specifically, as well as to extend social protection to cover diverse forms of work, including domestic work. Another area for action is to strengthen the role of the state and to prevent further segmentation of social protection systems, including through fragmented private-based solutions. Fourth is to make sure that effective social protection arrangements are developed to account for the new circumstances that workers may face as the reforms to the kafala system progress. Sorry, skipped forward there. And that finally, the last recommendation is to look at how migrant workers can be better protected against the long-term risks that they face upon returning to their home countries, and especially thinking about how there can be better coordination between countries of destination and countries of origin. So that is all we have time for now, but I'm happy to answer questions or discuss further in the Q&A or also after the event. So please do feel free to submit your questions if you already have them. But before we go into that Q&A session, I think it's helpful to complement this presentation that's been very much focused on rights as written in the legislation, to also think about how some of these entitlements are actually experienced by migrant workers in practice. And the topic of de facto access is something that we do look at in a forthcoming report. But in any case, as we discuss the laws today, it's great because we have the presence of William Goyce from the Migrant Forum of Asia, MFA. We're really delighted to have him on the call. So I'm just going to stop sharing my screen.
Yes, please. Thank you. Thank you, Christy,
and
welcome, William. And I just wanted to encourage all of you to continue submitting questions into the Q&A, which we'll get to in 10 minutes. Thank you. Over to you, Christy and William. William, could you unmute yourself, please? Great.
Can you hear me?
Yes, we can. Thank you so much, William. Thanks for making time to join us. I'll cut right into the questions then, since we don't have too much time. But as a kind of opening question, it would be great to hear, among the migrant workers in MFA's network, how would you characterize their experience of social protection in the GCC region? What are some key points that frequently get raised?
Hi, first of all, thanks for this, which I think is very, very timely, both as a study and as a direction to move forward in terms of migration governance. I would like to start with where Luca said. I mean, in the slides, the first kind of column you have there is social protection as a right, right? And I think this itself needs to be unpacked, because I think the approach to social protection, even now, is one of employer liability, what you call, we call it employer discretion, whether employer will give or not, kind of thing, right? And a lot of the challenges that we see are, for example, highlighted, and we've highlighted this particularly in the last 2-3 years, the whole issue of health, access to health, and we saw a huge failing there, kind of thing. Of course, we've got some numbers, but I think those numbers are just a fraction, a very small fraction of what is the real challenge out there for migrant workers. So you have that aspect of it. You have their migrant workers have their families and things like that, the schooling aspect, the dimension of right to education kind of thing. The whole aspect of returning in terms of taking savings and a life after work, pensions and things like that is a big, almost like a black hole in the lives and experiences of migrant workers. And we haven't even started looking into that. I know within migration governance today, there is talk of reintegration programs and things like that, but that is not coming from a perspective of rights. And again, I think that's important to keep that in mind, kind of thing. Both countries of origin and countries of destination. Countries of origin have started claim they are looking at it, but it's largely from a welfare perspective. And again, it's not a right perspective. And I think this is the big challenge, kind of thing. And particularly now, more than ever before, when we are seeing that health, which we have been, we know of a history when migrants had access to government health facilities in the 70s and 80s. But like you rightly said, that has shrunk, not expanded. That has not only shrunk, but in moving to the private sector, it has even become limited, kind of thing. So I think these are some of the things that we need to start looking at more from the rights and entitlements perspective as we look at this issue of social protection within the region.
Thanks, William. Yeah, I think that's absolutely a key framing to bear in mind, the question of rights. And you also mentioned the need for kind of better data here, and we definitely do. We have some small studies that kind of indicate really quite significant gaps between legislation as it's stated, or rights as they're stated in the legislation, and actual access in practice. But there isn't really sufficient kind of cross-country comprehensive data sets yet to show the extent of those gaps. I'm moving on then to the next question. What would you say are the kind of main challenges that you've noticed regarding migrant workers' ability to access social protection? So what are the kind of key factors that are creating this lack of access in practice and driving some of the gaps that you mentioned?
Again, I would come back to the rights thing, because even migrant workers themselves are unaware of this right that they have. It's not stipulated in their contracts as a right, kind of thing. So it starts from that beginning of that journey kind of process itself. Then in terms of accessing it, again, because a lot of this is employer liability kind of mechanisms are now moving towards private kind of thing, whether migrants even have that courage to ask their employer for benefits kind of things, sick leave and things like that, or even wages. When you have wage kind of subtraction, wage theft and wage non-payment of wages or end of service benefits and things like that. This is so tied into the labor migration systems that we have at the moment, that even the workers' ability, and that's why that whole question of workers coming together, the notion of collectively being able to ask for these rights kind of thing, that is a whole question that limits access in itself. So there's at the beginning, there's the sense of having this right, the knowledge, whether it is in their contracts. Countries of origin are doing bilateral agreements, but the question of having these in the bilateral agreements is a big question. Then the question of workers themselves coming together collectively and asking that. Then there's a question of, even if it does exist, how how broad is that kind of accessibility kind of thing. And I'll tell you what, now what we are seeing, for example, in the new contracts where it has become mandatory, the private sector kind of mandatory kind of insurance schemes that are being, I know employers are being asked whether you want this for compliance or is this more. So the question that is being asked by the insurance company to the employer is whether this is for compliance purposes. And so that limitation of just asking that question means whether there is really the question of, do you want to give this full coverage or not, kind of thing. That is the other kind of thing. So there's this dimension all along these hurdles that are put in the way of migrant workers, that even accessing them kind of thing. And then the support for accessing them. Again, because again, there is no the question of freedom of association, the question of local support, the question of being able to navigate the different processes, because even to access this, workers need some kind of resources, whether to go to the hospital or go for regular checkups and all of this. You need to have that kind of some kind of disposable resources to be able to get to these access this, and they don't have that even kind of thing. So I think it is important from that again to unpack what access means and what accessibility means and how it means and what it means in that whole spectrum of from day one of entry into the job kind of thing to return. Many workers, like for example, and this is classic, what are for us to think about, reflect about, the workers who came back, for example, in the last 2-3 years, how many came back without end of service benefits? So we talk about a life after work, but how many came back? And there is no question of them being compensated for that. So it's become like, it's almost a closed chapter in their lives. Workers have been forced to move on kind of thing, looking at 10, 15, 20 years of their lives coming to an abrupt end and no more. Shouldn't this be an ongoing conversation? Can it be an ongoing conversation? These are things we have to ask, and that's what I'm saying. The accessibility is not about accessing a system. The accessibility is about throughout, at any moment, to be able to access it. From day of entry right up to the day of return and after.
Thanks. Yeah, I think that's important to have that kind of whole timeline in mind when we're thinking about this question. Maybe just to close then on a slightly more positive note, potentially, which is to ask whether you feel there are any areas where progress is really being made. And if so, are there any indications of what could be kind of helping to drive that progress, or any particular lessons that we should be thinking of as we go forward?
I mean, the progress is already this study. Let us say this study is an indicator of coming as a progress. I think it was important to have a study like that to start looking at where are the gaps, what are the challenges, what could be done, and this we are beginning to see. It is a conversation that has started. It has started in different ways. The ITUC is talking about a universal social protection floor. There are people now talking about it. And I think that would be that's where, and we see even in the Gulf countries now, there are policies that are being introduced, and some governments are looking at it. It's come up in different spaces, like in the Abu Dhabi dialogue, there has been some brief passing mention of it. Can it become a pillar theme? Can it become bigger? Can there be more sharing of what is happening? The Gulf region has been known to be sharing of practices kind of thing. This is one strength of the Gulf region, of the countries sharing with each other their practices. Can the ILO support this kind of sharing of practices approach, broaden it, unpack accessibility and things like that? So there is this movement happening. I think this movement, this momentum needs to be sustained. Workers need to be brought on board, and community organizations and missions, embassies should start disseminating information of what is already available, should test what is already available. So we can already start looking at gaps, not to think that we've got the answer now, because a lot of policy work in the Gulf is also as if we already have the answer. But we have to look at policy implementation, and then continue looking at what are the gaps in the implementation. And I think this study could trigger something like that. If we can have these spaces for a good open conversation to look at gaps, momentum, sustainability, implementation.
Thank you to both of you. Thank you very much for these insights and for ending on that note on what progress has already been made. We're now going to move on to answering some of the many questions that have already come in from the audience, which is great. We apologize in advance if we're not able to answer all questions. We'll also try and answer some of them directly in the Q&A box. Christy, I'm going to ask you a first question that was submitted. We just ended up on that note that there is a lot of progress that has been made. And the question is, where there has been progress, what do you think has driven that progress? And what is, on the contrary to that, blocking further expansion of workers' rights? Would you be able to share some reflections on that? Thank you.
Yes, thanks, Jessica, and thanks. This is a question actually that we do explore in a forthcoming report that should be out later this year, that also looks at kind of the enablers and barriers of progress. And I think, I mean, there are various ones, but a few to mention would be the point around the COVID-19 pandemic. So I think Luca alluded to this in his opening remarks, but the pressures on employers around the kind of liabilities that they had to pay during the pandemic when many workers stopped working or ended jobs abruptly, that actually did really create a realization around some of the challenges of employer liability systems. That I think there was already an awareness of some of the challenges, but that really was a crunch point in kind of highlighting those issues. So that's been one potential driver of some change. Another one, I think, is the international commitments and attention that sometimes can support and encourage GCC governments to be looking to make some changes. So, of course, the FIFA World Cup in Qatar is one example that has led to a number of conversations and work to see what policies can be changed. That's a work in progress, but I do think the driver is there. And actually, it was interesting in the research that it was also mentioned that even where GCC governments don't actually ratify international conventions, sometimes the presence of those conventions and standards can help to build some momentum for change. So an example there was the Domestic Workers Convention from 2011. The fact that we've seen this number of new domestic worker laws coming in over the last decade could in part be attributed perhaps to that convention. That's not to say that there aren't gaps still to be filled, but those are a few drivers there. But the barriers are still quite substantial on the legal side. So basically the political economy that we see in the region, the fact that a lot of GCC citizens don't work in the private sector, and you've had this model where they've been looking more to the public sector, does of course mean there isn't as much drive from citizens to be improving provisions in that sector, whether for nationals or non-nationals. Also the dependency on kind of a low wage, low productivity labour model in the region has, I think, held back employers and also governments themselves from pushing for change. And then on the side of country of origin governments, so where migrants are coming from, they have to balance a number of diplomatic and political and economic priorities that sometimes mean that the rights of the workers from their countries aren't always at the very top when they have agendas discussing policies.
Great, thank you, Christy. Actually, on the topic of country of origins, we have a number of related questions, which I'm going to give to you, Luca. So there was a question from Neha asking whether there were good examples of the portability of social security provisions and or harmonization of social security schemes between countries of origin and destination. And then Rashid also asked a related question where he asked, what are you thinking about the legality of pension programs for workers who are guests in a country and will not be resident in that country after retirement? How can such agreements be enforced, and does it require a bilateral legal infrastructure? Over to you, Luca.
Yes, thanks, Jessica. And indeed, the issue of portability is very much at the center of what we're trying to achieve here. And we tend to think of portability only in the case of pensions, but it really matters also for other type of benefits. You think about a worker who suffers for an injury on the workplace, came to the forefront of the news during the FIFA World Cup, loses ability to work, returns home without any form of long-term compensation. That is a matter of portability, how to ensure that that injury compensation can be enjoyed upon return home. So it is really a complex matter. And requires ultimately coordination between sending countries and countries of origin. At the moment, that coordination is hindered by the fact, again, by the employer liability nature of provisions in GCC countries. It's virtually impossible to arrange for any portability of benefits, which are solely the responsibility of an individual employer to pay. It would require that employer to unilaterally decide to, for example, make those benefits available overseas, which of course will never happen. So the reforms that Christy has been talking about, which puts more at the center national institutions in the GCC to honor protection and provide social protection benefits, are the entry door for any possible solutions also in terms of portability. Because once national institutions are involved, say social security institutions in countries of destination in the GCC, then those countries could enter agreements with the sending countries to allow for better portability. In the absence of that, at the moment, portability is only provided through what we call unilateral measures, meaning in some cases, for example, the schemes that exist for employment injury in Saudi Arabia have in the past at least allowed for payment of benefits abroad without any agreement, but simply as a unilateral decision of sending countries systems to allow payments of benefits abroad. On the other side, also, sending countries have put in place unilateral mechanisms that offer some form of portability. For example, we know about the Philippines, who facilitates and favors participation into social security through systems in the Philippines. And similar steps are now being taken in Nepal and other countries, basically to give an option, or in some cases mandate, migrant workers in the GCC to contribute to social security systems back home. So when they return, they can enjoy. Now, the problem with this approach is that these unilateral measures by sending countries typically don't involve employers in the financing. So they're only basically relying on the capacity to finance of the workers themselves. And that capacity to finance is limited. Final point on portability, not always, we need to interrogate, I think, more openly the preferences of migrant workers themselves. At the moment, there is a strong preference to cash out, if you want, as much as possible from the end of service and other benefits and invest that in sort of businesses back home. So there is a high demand for cash in hand as workers leave the GCC. How to switch from a model where workers are reassured that they can receive back home in the long term through pensions, and therefore that their preferences may shift from cash today to better protection tomorrow. So we need to do more work in engaging and understanding what migrant workers want in terms of a better social protection system. Back to you, Jessica.
Thank you. We have time for one more question before we move on to the next segment. William, I'm going to ask you a question which came in the chat. And this question is, I was wondering if these policies pay special attention to the gender differences faced by different groups of migrants. Secondly, to what extent do these policies take into account the informal sectors where most migrants work, such as domestic work? Over to you, William. Thank you.
Thanks a lot for that question. And I think that is another very important question to ask, and both are linked. In some ways, one of the biggest sector, women migrant workers in the Gulf countries is a big sector is domestic workers themselves. And many of the domestic workers are women, because you have the others, drivers, gardeners as well, who are lumped within that same category. But many of the domestic workers themselves, who are women, find none of these policies really look at their experience kind of thing, or their accessibility for them. Because a lot of this issue of accessibility then remains largely upon the head of the household or somebody in the household kind of thing. And we've got so many cases reported excessively over time. Like a story told constantly is the magic of Panadol. Okay, so whenever a domestic worker has a problem, Panadol is the issue. Panadol is the answer. Like, and that's it. And so this has been a long-standing story, a narrative that we have had within our circles in the informal sector. So, and especially of women, I think it's something that we need to look at. Even, for example, pregnancy, and maternity rights. There is no question of even discussion or debate about this kind of thing, and again, this has to fall squarely within the realm of work. Today, in some parts of the world, you're talking about extending maternity leaves kind of thing, 6 months and things like that. For domestic workers, the minute you get pregnant, you are flown back, repatriated. So where is the social protection or accessibility there? I think this thing needs to be rethought of again within the context of women and women migrant workers and within the informal sector. So definitely a very important area to make further, much more progress.
Great, thank you, William, and to all the other panelists for answering the questions. And thank you also for the great questions which were submitted. We didn't manage to answer all of them. We'll try to get to them in the second Q&A, and please also submit more questions. We now move on to Leah and Khalil, who will discuss end-of-service indemnity. This is the key social protection benefit that migrants are currently supposed to receive, as you already saw in Christie's presentation. There have been many calls in recent years to reform end-of-service indemnity, both from the perspective of migrant workers as well as employers. So this is a critical discussion to have. Over to you, Leah and Khalil.
Thank you. Thank you, Jessica. Good afternoon to all, and thank you, Khalil, for joining us. Today, together with Khalil Buhazaa, Director of Labor Affairs at the GCC Executive Bureau, we aim to discuss the newly released ILO policy paper dedicated to the issue of end-of-service indemnity for migrant workers in the 6 GCC countries. So it's more of a deep dive on that topic that was already mentioned before by previous panelists. This paper is part of the ILO publication series, extending social protection to migrant workers in the Gulf countries. This policy paper seeks first and foremost to accompany the ongoing efforts in the Gulf region dedicated to the reform of the end-of-service indemnity system. The benefits of the end-of-service indemnity system are one of the only social protection mechanisms in the Gulf countries that provide income protection to migrant workers. They are established by the labor law and oblige employers to pay benefits to migrant workers when their employment ends. These systems are similar across the GCC countries and normally pay a lump sum gratuity calculated as a multiple of the final wage. So for example, if a worker has worked for 10 years with the last wage being $500, at the end of the employment relationship, the employer is obliged to pay 10 months multiplied by 500, $5,000. However, such payments are in lieu of a true social protection benefit, and from a social security perspective, their effectiveness is very limited. So the shortcomings of the end-of-service indemnity system are many, and we try to document that in the paper. So the system does not provide effective protection against life cycle risks. The benefit levels are insufficient to meet the minimum levels reflected in ILO standards. Benefits are not related to any specific contingency. to any specific contingency. They only provide lump sum payments instead of periodical benefits. These schemes are also characterized by weak enforceability, and this is probably one of the core issues that countries are struggling with today, because of complex legal processes, power asymmetry, and the risk of insolvency and bankruptcy. And in that case, the employer cannot pay the indemnities. Also, such schemes lack solidarity in financing and collective risk pooling. Most importantly, also, the central principle of equality of treatment is not respected in these systems, whereby nationals and non-national workers are effectively subject to two distinct social protection systems. Today, several GCC countries have accelerated reforms of end-of-service indemnities. Approach vary in scope and vision, but are not always aligned with this progressive agenda for the realization of migrant workers' rights, social security, in line with international standards that we also try to reflect and assess in the paper. So we have a wide array of attempts today in the Gulf, whether it's guarantee schemes that have been put in place to ensure the payment of end-of-service indemnities, or we have market-based solutions, or for instance, also the creation of national funds, or like in Qatar. We have also individual pension saving schemes, but here, and also the creation of national provident funds, or the attempts of their creation. But here I would like to ask Khalil, who follows closely the reform and adjustment attempt in the region. So Khalil, what is your assessment of this trend? What are the drivers behind the attempts and these efforts to reform the end-of-service indemnity in the entire region? Over to you, Khalil.
Thank you, Elia. Just to mention that I will speak in Arabic. الحماية الاجتماعية يعني معقد بأكثر من مجال. الجزء الأكبر الآن مع التحولات اللي قاعدة تحصل في عالم العمل، التحول نحو العمل المنصات، الانتربرنور، والعمل الجزئي والعمل من خلال المنصات الإلكترونية، كل هذه ستلقي بتحديات أكبر على قدرة المؤسسات الحماية الاجتماعية لتغطية كل العمال بمختلف فئاتهم. الآن إذا بنرجع على مستوى دول مجلس التعاون، نعم هناك تحديات كثيرة طوال السنوات 20 أو 30 سنة اللي فاتت. هناك مسائل أو إشكاليات تتعلق بكيفية إدماج العمالة الوافدة في نظم الحماية الاجتماعية. هناك في تغيير مثل ما أشارت ليا ولوكا أيضا في من خلال حديثهم، في تطورات أو يعني خطوات لنقل وإن كانت بطيئة، ولكن خطوات ممكن ملاحظتها في مسألة التحول في القناعة وفي المفهوم لدى دول مجلس التعاون في مدى حماية أو مدى شمول العمالة الوافدة في نظم الحماية الاجتماعية. أنا في تقديري هذه المسائل يعني مدعومة بأكثر من عامل. العامل الأول هو تقريبا اليوم، او عفوا يعني قبل لا استدرك لهذه النقطه، الان كل دول مجلس التعاون بلا استثناء عندها مراجعات الى نظم الحمايه الاجتماعيه، طبعا بتفاوت وبوجهات نظر مختلفه، ولكن ما هو مشترك بين كل دول مجلس التعاون نجده في البحرين، نجده في عمان، ايضا الامارات، السعوديه. جميع هذه الدول قاعده تشتغل او تعمل على اعاده تطوير أو إعادة صياغة نظم الحماية الاجتماعية لتكون أكثر شمولا للفئات المستهدفة. هذه المسائل أنا أعتقد مدعومة برؤى موجودة تنموية في دول المجلس، تسعى إلى تغيير هيكل الاقتصاد في دول المجلس، تسعى إلى أن يكون سوق العمل أكثر تنافسي وأكثر قدرة على استقطاب العمالة الماهرة أو ذات الكفاءة العالية، وبالتالي توفير بيئة حاضنة أكبر إلى هذه النوع من القوى العاملة. أيضا الجانب الثاني يمكن أشار له أكثر من زميل، موضوع التحديات التي كشفتها جائحة الكوفيد على أسواق العمل وعلى قدرة أصحاب العمل في الوفاء بالتزاماتهم تجاه العمال بما ينص عليه قوانين العمل. وجدنا أن كثير أو جزء يعني كبير من أصحاب العمل أصبحوا غير قادرين على الوفاء بالتزاماتهم فيما يتعلق بالاند اوف سيرفيس اندمنتي للعمال، او انهم الملاءه الماليه خصوصا في حاله في حاله الازمات. نجد بان راس المال او القطاع التجاري يحاول قدر الامكان انه يحافظ على الليكويديتي اللي موجوده عنده، ولا يستثمرها او ولا يمنح، خلينا نقول، الناس او العمال حقوقهم في هذا الجانب. بالتالي هناك الان في صيغه موجوده عند او في على الاقل توافق عند دول مجلس التعاون ان ناخذ خطوه قدام، او خطوه الى الامام من اجل مراجعه نظم الاند اوف سيرفيس امنيتي. والان هناك في مناقشات، يمكن لوكا وليا احنا كنا من تقريبا اكثر من سنه ونص الان في حوارات مستمره، عقدنا فيها ورشتين عمل، بين واحده كانت مقتصره فقط على الحكومات، ولكن الورشه الثانيه تم توسيعها من اجل اخذ مرئيات اصحاب العمل والعمال. كل هذه الحوارات قاعده تمشي بشكل ممنهج. متوقع ان خلال هذه نهايه هذه السنه بعض دول مجلس التعاون بتكون صدرت قوانين جديده تنظم مسألة الحماية الاجتماعية وتجعل إطار الحوكمة أكثر وضوحا وأكثر شفافية لها. في هناك أيضا توجهات بكيفية ربط مسألة الحماية الاجتماعية أو الإند اوف سيرفيس اندمنتي مع نظم حماية الأجور اللي تطبق في كل دول مجلس التعاون. ممكن بس نقطة أخيرة قبل لا أختم في هذه الجزئية. وجدت بعض الملاحظات فيما يتعلق بقدرة العمالة الوافدة على الوصول إلى الرعاية الصحية أو إلى إصابات العمل. ما بأدخل في هذا الموضوع بشكل ديب، ولكن حسب معلوماتي وحسب قربي من الجانب، مسألة الولوج إلى الرعاية الصحية مسألة ما يمكن الجدال عليها. نعم، قد تكون في ثغرات، قد تكون في انتهاكات أو تقصير من أصحاب العمل، ولكن لا يمكن بشكل من الأحوال أن نعتبرها ترند موجود في المنطقة. أنا بكتفي عند هذا القدر، شكرا لي.
Thank you, Khalil. I have been receiving messages that we have to quickly wrap up, but before so, I would like to add that in addition, the paper, in addition to the fact that it assesses the end of service indemnity system and the limitation that you have just mentioned, it also assesses the current attempts of reforms that are happening in the region against international labor standards. And for that, accompany also the reform, this paper proposes 3 concrete policy solutions that we have discussed together in the workshops, Khalil, which may also be used as a roadmap for progressive realization of social security rights. These 3 options that can be also considered as 3 steps is first, the creation of a standard provident fund, and the paper explains about this solution. So instead of being liable for individual end of service indemnities benefit, the employer in that case would pay an equivalent monthly contribution into a publicly managed national provident fund scheme, which would take the responsibility for the administration and payment of benefits. And this would address mainly the issue of enforceability. The second step would be to enhance this provident fund with a several set of features, which would include a comprehensive range of risks and contingencies, would include all categories of migrant workers, would make the employer contribution rates to match those of national workers, and could also combine with contributions from workers, initially on a voluntary basis. It can also enhance the predictability of benefits, and provisions of periodical payments, including upon return in countries of origin. And last, the last step is the inclusion of migrant workers in national social security schemes. Fully including migrant workers in national security system is the only option that fully is in line with international social security standards. But this solution comes with challenges and opportunities, which the paper attempts to chart for the consideration of stakeholders and policymakers. I will stop here, and we can maybe, if there are questions, address additional points. Thank you, Khalil.
Thank you very much to these interesting insights, for these interesting insights. Khalil, you didn't get that much time to speak just now, so I'm going to throw you 2 questions from the Q&A. The first one is around the conflict of interest that might arise between Gulf states and the private companies. So the person in the chat said there are quite a high number of migrant workers employed by companies that are owned or partially owned by Gulf governments or contracted by them. And this person asks, what additional measures can be implemented to tackle this situation, going beyond mere advocacy for improving social protection provisions? So that's the first question around the conflict of interest. I'll mention a second one already as well, which is around the role that countries of origin countries can play to advance this agenda. So could you talk about the extent to which DCC countries are working today on the coordination of social protection of migrant workers with countries of origin? So for example, through bilateral agreements. Thank you, Khalil.
الثنائية مع دول المنشأ.
أنا أعتقد أن الحوار بين دول الإرسال ودول الاستقبال مسألة جدا مهمة في تطوير نظم الحماية الاجتماعية أو تطوير الكوريدورز بين مختلف الجهات. نعم هناك تحديات يمكن أكبر في دول الإرسال فيما يتعلق بقدرة السوشيال سيكيورتي سيستم في هذه الدول على استقطاب أو حتى على تنظيم مسألة الحماية الاجتماعية ودمجها بما قد يكون موجود في دول مجلس التعاون. يعني لنعطي مثلا فرضية معينة، لو رغبت في أي دولة من دول مجلس التعاون بكرة تشمل جميع العمال بلا استثناء في نظم الحماية الاجتماعية، مسألة إدارة هذه الأموال وإدارة هذه الحقوق سنواجه بتحديات كثيرة في دول الإرسال. الآن من خلال التعاون، من خلال مثل ما أشار يمكن ويليام في مداخلته فيما يتعلق بالكوريدورز اللي هو الديالوج كوريدورز بين دول مجلس التعاون كحوار أبو ظبي مثلا، أو حتى الآن هناك في توجه وعمل محموم لفتح مسار آخر من الحوار بين دول الإرسال في المنطقة الأفريقية أو في القارة الأفريقية مع دول الاستقبال في دول مجلس التعاون والمنطقة العربية. أنا أعتقد هذه النوع من الحوارات هي مسألة كفيلة أو مهم طرح موضوع الحماية الاجتماعية والبدء في تفكير في آليات وبرامج وحتى مسائل يعني خلينا نقول خارج الصندوق إن صح التعبير، في كيف أن احنا يكون في win-win situation للعمال ولأصحاب العمل وأيضا لدول الإرسال ودول الاستقبال، بحيث نضمن بأن يكون العامل سواء بعد انتهاء فترة خدمته في دول مجلس التعاون أو بعيد، يعني في أسوأ الأحوال إذا كان تعرض إلى نوع من إصابة العمل أو لا قدر الله حالة من حالات الوفاة، كيف يتم تعويض العامل بشكل عادل وكيف ممكن دمج ما هو موجود في دول الإرسال مع دول الاستقبال. أنا أعتقد أرد مرة ثانية أكرر مسألة الحوارات جدا مهمة، والآن الحوارات ممكن تصير بشكل ثنائي من خلال الاتفاقيات أو مذكرات التفاهم التي تتم بين دول مجلس التعاون على حدة، أو من خلال السياق الجماعي سواء في حوار أبو ظبي أو في الحوار المرتقب اللي بيكون مع دول المرسلة من القارة الأفريقية، وأيضا في الإطار الدولي نتكلم احنا على منصة مؤتمر العمل الدولي أو إطار منظمة العمل الدولي، هي أيضا توفر فرصة كبيرة للدول في يعني تبادل الأفكار وتبادل التجارب. هذه فيما يتعلق بالشق الأول. إذا عندي وقت بنتقل إلى الشق الثاني. اوكي، الان فيما يتعلق بالعلاقه بين الاجهزه الرسميه او الحكومات وشركات القطاع الخاص، هناك في يعني ايضا حتى في اتفاقيه خاصه صادره من منظمه العمل الدوليه تنظم. So about the relationship between the government and the private sector when they let's say working on a public contract, on my opinion, and even there is an ILO standard governed what the liability on the government when they provide or when they give a private sector a contract for a public work. In my opinion, or even in this in reality, there is an law enforcement before signing the contract and during executing the contract. There is a supervision from the government institution, from the labor inspection. So I don't think that when the government gives a private sector a contract to do, I don't know, any kind of work that they will in the same time will, let's say, okay, go and do whatever you want. Again, I think there is an inspection, and if any worker, and this has happened many times with some of our colleagues, when they reach us that there is a problem here or there, you can reach the government department, like the Ministry of Labor or the Labor Inspection, and I am 100% sure that they will do their best to solve the issue, or at least to minimize or to stop any abuses that happened against the worker. Sorry if my language doesn't help me to express what I am saying, and thank you.
Thank you, Khalil. That was actually very clear. Thank you. Yeah, we've got a lot of excellent questions. We won't be able to get to all of them. A few colleagues are answering some of them in the chat, and I'm going to hand 2 final questions to Luca to answer very briefly. I think the first question picks up a little bit on what Khalil was already talking about just now. There were quite a few questions in the chat around enforcement. For example, a question from a respondent who noted that in Qatar, the sponsorship system has not been abolished in practice. And the person asked, to what extent is legislation monitored and enforced? And then final question on a more forward-looking note. Does the completion of the World Cup in Qatar change the momentum towards expanding rights and welfare for migrant workers in the GCC? Has the bar for success in expanding social protection provisions moved? Thank you, and please try to be as quick as possible.
Yes, thanks, Jessica. Maybe I'll start from the second. Is there momentum? I think William spoke to this a bit, and for sure, I mean, having worked on this subject over the past couple of years, we can say that there is definitely a new openness to talk about the subject of extension of social protection to migrant workers in the GCC. As Khalil mentioned, the GCC Bureau has convened already 2 regional workshops to discuss specifically the end of service reforms. And during this time, and I think William also spoke about how much in the GCC there is a lot of interest in observing which countries are moving in which direction. And we have seen that there is active efforts at reforming end of service, open discussions and proposals on the table at reforms of end of service. We know about Bahrain, but also in Oman, in Qatar, in the UAE. Just in the course of few months, many project teams have activated initiatives that look at rethinking the paradigm, at least in terms of ensuring better mechanisms to allow for that benefit specifically to be paid. But you will see also in the report how on health insurance there has been quite a significant shift in thinking and approach over the past few years, also with some risks. So not all those changes necessarily go in the direction of international labor standards, but there is openness and there is a fertile space for this agenda to advance. And I want to link it to the second question. I mean, what to take forward in terms of priority and focus. Clearly, we know already that from the past, and someone refers to the ongoing attempts at reforming kafala, there is a big space between issuing new legislation or new policy and actually that policy turning into effective, improved conditions for workers. So the focus on enforcement, on implementation is critical, and there the need to develop broader partnerships that can actually help to build on the momentum that these new policy openings provide, these new reforms, the upcoming reform in Oman and maybe others in the GCC will need to be met with equal ability of partners on the ground to support migrant workers in exercising their rights, the rights that already exist under labor law and the right that perhaps will exist after these reforms take place. And there really calls in question the need to build broad partnerships that should involve civil society, but also workers' organizations. Someone mentioned the diplomatic missions and countries of origin, private sector, to really make a push on this agenda, which few months back was, to be honest, a bit of a taboo. Nobody was talking about the subject matter. Now, clearly, it is an open subject of discussion, and countries of origin also needs to perhaps do better to put it in their radar and to also focus on this matter as part of the bilateral negotiations that take place, recognizing it is a regional agenda. Migrant workers move within the GCC, and the portability of benefits also need to take that element into account to allow migrant workers to retain and accumulate their benefits as they combine periods of careers across different countries in the GCC. Back to you, Jessica.
Great. Thank you so much, Luca. I'll now turn to Patricia for some final reflections from the perspective of the international community. Patricia, what are your thoughts on the webinar today, and how can the international community further support this momentum of change?
Thank you very much for giving me the floor to make a few concluding remarks, and thank you all very much for the rich discussion. I think one thing which is for sure, it is important that the positive contribution migrant workers make through remittances and creating wealth and welfare in the countries in which they work needs to be matched by an approach which helps them to access and to exercise their rights, including social protection. I have heard and read on the chat today that social protection is one piece of a bigger puzzle. It needs to be studied, and this study that data that we have supported is very important at the policy level, but also in terms of practical implementation. So that is very important, but it is for me, a very important lesson is we need to continue to work on all levels. We will start to work, and we have started to work on social protection, but we also need to continue to work on ethical recruitment, on access to justice, because as I could read in the chat, workers have practical problems and they need a remedy to these wherever they work and wherever they live. So I think it's a two-pronged approach that we will continue for sure at SDC, is to work more at this practical level through our programs on access to justice, giving voice to migrant workers, giving voice to organizations, working with them, and the more strategic level where we support organizations such as the ILO or research organizations, and also the governments in the region to study systems, to look at what the international standards are, and to see what kind of systems can be introduced. And there too, I think, is two levels. One is the systems level, the good practices from around the world, to study those, but then how do you take this forward? And I have appreciated the study on the portability of social benefits. And it seems to me you're taking a system that is already in place, which is not perfect, and you advise how this can be improved. Because of course it's important for us to show concrete results for the people we serve. Therefore, I appreciate this two-pronged approach where we at the same time, we look at the system, we look at the standards, we see social protection as a holistic issue, which is a right connected to other rights, such as the right to health. And we look at practical support to migrants. As I said, we do it through programs on access to justice, supporting civil society, and the ILO looking at studying the systems, but also taking practical steps to make some improvements. So in terms of recommendations, I think from today, we need to maybe become a little bit more granular. There are different types of professions, different types of workers. So how can we devise systems which serve different types of professions? And also, how can we work in a multi-stakeholder approach with the private sector, with the different sectors, the different companies, the different employers? And how can we bring in also the voice of the civil society? And then on the side of working with governments, and we're doing this also on behalf of the Swiss government, to share the good practices with governments and to push for further reforms. And then I think a big last point is we need to make sure that the impunity ends. Many workers have a lot of rights to claim, and to see what kind of accountability mechanisms at all levels governments can put in place, civil society and other actors, so that they can actually claim rights while we improve the system on the long term. So with this, on behalf of the STC, thank you very much, and I look forward to continue this conversation.
Thank you, Patricia. Unfortunately, it's already time to wrap up our really interesting conversation today. I would like to thank our excellent panel for sharing their valuable knowledge with us. And also thank you to the audience for joining us today and for your really critical questions. And many thanks to our interpreters, Maisa and Rami. We hope that this event has highlighted the challenges faced and the urgent need to extend social protection to migrant workers, but also the really important work underway to achieve reform on paper and in practice. We invite you to take a look at the new reports which have informed the discussions today. I think the link just came up again in the chat, and do reach out to any of us to discuss the findings and implications further. Over the coming months, we will continue to build on the findings and will hold a follow-up event in the autumn. Until then, thank you for being here and goodbye.